Ladies and gentlemen, welcome to this first lecture of this year's Readers' Lecture Nights. Welcome to all those in our new lecture theatre, but also those of similar number who are online, both in London and across the country. The broad theme of the lectures this year, which I followed, say, for one of the four, is of the relationship between the executive and the courts. A perennial, but somehow it's had an extra and sharper focus in recent times, and it seemed to me that it was something that was worth developing and considering from various perspectives. Other perspectives that we will have this year include, in 3 weeks' time, on March the 6th, Professor Timothy Endicott, the Vinerian Professor of English Law at Oxford, will be giving a lecture on the subject from the position he holds. And then in November the 13th, Dominic Grieve will be addressing the subject from his position as a former Attorney General. Well, tonight we have the perspective from, as it were, someone who ran the country. And we are very privileged and delighted to welcome Lord Butler, as will be well known, hardly needs saying. He was Cabinet Secretary and head of the Home Civil Service from 1988 until 1998, 3 prime ministers in those 10 years, having previously been private secretary to 2 prime ministers. He has continued to be active in public life, not least as a crossbencher in the House of Lords with a particular focus on constitutional issues. Well, thank you very much, Lord Butler, for crossing Middle Temple Lane from that other place where you are honorary bencher, and we greatly look forward to your talk.
Well, thank you, Michael. I feel very honoured that you've invited me as a non-lawyer to give this lecture, and also a little overawed. Michael asked me to speak on the basis of my experience in the civil service about the relationship between the executive and the courts. So I ask for your forbearance if I offer what is inevitably a layman's view, or some in my profession might say a victim's view. Actually, when I began to think about it, I realized that I was a little more qualified to speak on the subject than I'd first supposed, because my career in the civil service coincided with the development of judicial review over the years, or as others might say, the growth of judicial activism. And coincidentally, although Sir Michael would not have known this, I had a peripheral involvement with 2 of the landmark cases in this development. But more of that in a moment. Before you fall asleep, and while we've got the distance audience, I can't really bring them into it, I want to start with a little audience participation. How many in this audience think that the Supreme Court was entitled in the autumn of 2019 to countermand the Queen's prorogation of Parliament, an action which she had taken on the Prime Minister's advice? If you think that the Supreme Court was entitled to do that, please raise your hand. And if you think that the Supreme Court was not entitled, raise your hand. Well, I think we have a substantial majority in favor. And how many think that the Supreme Court was right in 2017 to rule that the government needed an act of Parliament to authorize giving notice to the European Union of our intention to leave the Union in accordance with the people's wishes as expressed in the 2016 referendum? How many think that the Supreme Court was entitled to take that view? Yes, probably the same. And how many thinks it wasn't entitled to take that view? Yeah. Again, a considerable majority, perhaps a greater majority in that case. Now, I have a firmly held opinion on the answers to both these questions, but again, in the hope of keeping you awake, I want to hold you in suspense about that while I speak about the development of administrative law as I saw it during my career. I joined HM Treasury in 1961, a very long time ago, and I was posted to the public expenditure side of the department. There was no doubt about what my job was. It was to do my utmost to stop other departments spending taxpayers' money. As it happened, there fell within my area of responsibility the public expenditure consequences of a case which the Burma Oil Company brought against the government and which turned into a very significant development of judicial review. The Burma Oil Company, later known to us as BP, had brought a case against the government for compensation for the destruction of their oil fields undertaken in Burma during World War II to prevent the oil fields falling into the hands of the Japanese. When this case was brought in the 1960s, the government believed that it could defend itself by relying on the doctrine of Crown immunity. The essence of this was that proceedings could not be brought against the Crown for actions such as the destruction of these oil fields, taken under the royal prerogative for the defense of the realm in wartime. The case went to the House of Lords, at that time, of course, the Supreme Court, who decided by a majority of 3-2 that because the damage had been undertaken in defense of the public, the owners were entitled to compensation from the public purse. The public expenditure repercussions of this decision were potentially enormous. The case was a precedent for all those whose property had been destroyed by the government as part of the conduct of the war. The Treasury, of course, did not want to spend the huge sums which would be involved. The government got out of the liability by passing with retrospective effect the War Damage Act 1965. The courts had spoken, but the executive, by parliamentary action, overruled the courts. This was constitutionally legitimate, but it was highly controversial. Nevertheless, the principle that actions taken by the government under the royal prerogative could be challenged in the courts was established. As a junior official in the Treasury, I had a worm's eye view of this episode, which took place on the patch of public expenditure which I was trying to control. Fast forward 20 years to 1984, and I was principal private secretary to the Prime Minister, Margaret Thatcher. It was in this capacity that my second brush with judicial intervention took place. Following industrial action by the civil service trade unions, Margaret Thatcher decided that the staff of GCHQ, the government's intelligence listening center, should be banned from trade union membership so that they could not be called out on civil service strikes. In this respect, they were to be put in the same position as the other intelligence agencies, MI5 and MI6, and the armed services. The ban was imposed by an order in council under the royal prerogative, requiring no parliamentary procedure. The Council of Civil Service Unions brought a judicial review of the order. At the first instance, Lord Justice Glidewell ruled that the government's processes had been defective because the staff of GCHQ should have been consulted first, and that therefore the order in council was invalid. The Court of Appeal reversed this decision, on the grounds that judicial review could not be used to challenge the use of the royal prerogative, rather going against the decision that had been made in the Burma oil case. The House of Lords decided that an order made under the royal prerogative could be subject to judicial review, but that some areas should be exempt, and one such area was national security. On these grounds, the House of Lords concluded that this particular order in council should be exempt from judicial review, and so the government won its case. The ban on trade union membership at GCHQ lasted for 13 years until it was removed under the Labour government in 1997, and I'm not aware of any problems which have resulted from its removal. In the course of his judgment in the House of Lords, Lord Diplock specified 3 criteria for challenging executive decisions, which have really become the locus classicus by which these cases are considered. The first was illegality, that is, misinterpretation of the powers in a statute. The second was irrationality, that is, the so-called Wednesbury test, that the decision was so unreasonable that no reasonable authority could have come to it. And the third was procedural impropriety. And I think I'm right in saying that these still stand as the 3 main grounds on which executive decisions can be challenged. Now, since I've been invited to give a personal perspective on the development of judicial review, I digress for a moment to make 2 personal observations about the court judgments in these cases. I must say that I thought that Lord Glidewell's judgment was naive, because his finding that the staff of GCHQ should be consulted about a ban on their trade union membership was like a requirement to consult one's children about whether they should spend their pocket money on lollipops. There was no doubt what the result of that consultation would have been. As regards the House of Lords judgment, also, I did not share their lordships' confidence in the intelligence services to the extent that their actions should exceptionally be immune from judicial review. While I have great respect for the integrity of our intelligence services based on personal experience, I don't believe that their activities should be immune from scrutiny. My second observation following the GCHQ case is of a different sort. Lord Justice Glidewell's original judgment overturning the government's ban on trade union membership naturally caused a political sensation. It was a slap in the face for Margaret Thatcher, which the Labour opposition was bound to exploit. And I vividly remember that she and I first learned of it when we saw on a newspaper hoarding, as we were traveling back in a car from an engagement to the city, the headline, "Government ruled illegal in the GCHQ case." And we learned that from a newspaper hoarding, because means of communication were not then as they are now. There were no mobile phones. It was a bad time for Margaret Thatcher. It was during the coal miners' strike, and the dockers were threatening to come out in support of the miners. Nevertheless, Margaret Thatcher's reaction was immediate. "We will, of course, appeal against Lord Justice Glidewell's judgment," she said. "But if our appeal fails, the ban must be reversed." She had an unshakable respect for the rule of law. The conclusions of the court might be inconvenient for the government. They might even be damaging to the national interest. But in her book, they had to be obeyed. Fast forward to modern times. Administrative law has now evolved to the point where every civil servant needs to familiarize himself or herself with a government publication called The Judge Over Your Shoulder. Now in its 6th edition, and ironically given the acronym JOYS, JOYS. Now, the definition of administrative law in the introduction to this document runs as follows, and I quote, "Decisions by public bodies may be challenged through the court procedure known as judicial review. A claim for judicial review means a claim to review the lawfulness of an enactment or decision, action or failure to act in relation to the exercise of a public function," end quote. We need to ask how it is that we've reached a situation in which it has become acceptable to give judges, who are after all not elected, the power to nullify decisions of public bodies who may themselves have been democratically elected, including the government itself. Now, someone defending this situation may give many reasons, and certainly one is that the areas of public life in which public bodies impinge on private individuals and organizations have grown hugely over the years. The ways in which this has happened include laws which the government itself has passed and regulations made under them, such as equalities and human rights legislation, and also entitlement to social security benefits, and to international treaties which the government has entered into, such as the European Convention on Human Rights and membership of the European Union. Decisions affecting the public made under these powers have to be monitored and the public safeguarded from mistakes or errors of procedure. Nevertheless, the courts must be careful. It would be wrong for judges to usurp the role of politicians or trespass on ground occupied by Parliament. I remember a minister once saying to me, it wasn't David Hunt, I don't think, in respect of judicial review, "What is the point of being Secretary of State for Transport if I cannot close the overnight sleeper service to Fort William?" Lady Hale, as President of the Supreme Court, defended the court's intervention in the government's prorogation of Parliament in 2019 as follows, and I quote, "Although the courts cannot decide political questions, the fact that a legal dispute concerns the conduct of politicians or arises from a matter of political controversy has never been sufficient reason for the courts to refuse to consider it. Almost all important decisions by the executive have a political hue to them. Nevertheless, the courts have exercised a supervisory jurisdiction over the decisions of the executive." I end the quote. Careful criteria have therefore had to be developed to draw the boundary between the executive's role and the court's role. The court's role relates to the processes by which a decision is taken, not the merits of the decision itself. Though, of course, it has to be admitted that the criterion that a decision is so perverse that it could not have been reasonably taken means that the decision between merits and procedure can be very thin. In order to protect themselves against judicial intervention, staff of public bodies in these days have to test their decisions against a demanding set of criteria set out in a checklist in The Judge Over Your Shoulder. This lists no less than 24 questions which decision makers are advised to ask themselves before taking a decision. As I read them, the civil servant in me thought, no wonder that officials, including those judging asylum claims, take so long to reach decisions. But I also asked myself, as a former bureaucrat, do I resent the fact that the existence of judicial review requires decisions by public bodies to be put through such a fine sieve? And my answer, speaking as a former head of the civil service and now a parliamentarian, is that I do not resent it. I think that these criteria contribute to a fair and well-governed society. Although I do worry about reports these days that over 80% of judicial review cases relate to immigration applications. It looks as if our liberal regime may be being exploited in this respect. So, should we conclude that with the availability of judicial review, all is well in our governance arrangements? And my answer is not entirely. In the foreword to The Judge Over Your Shoulder, Susanna McGibbon, the current head of the government legal service, says this, and I quote, "The rule of law requires a balance of power between the government, parliament, and the judiciary." I'd like you to keep those words in your mind, a balance of power between the government, parliament, and the judiciary. The danger always is that in that balance, the government, i.e. the executive, is overweight. The history of our nation's governance, perhaps of the governance of all nations, is the balance between rulers and the ruled, between the government and the public. And I don't need to remind you of the landmark episodes which have shaped the balance in this country. Magna Carta, Simon de Montfort, the Civil War and the Restoration, the Glorious Revolution, the Bill of Rights, electoral reform. In our Constitution, Parliament is supposed to be sovereign. It is elected by the people, and the executive answers to it. Now, we shouldn't be surprised that the relationship between the executive, the government, and Parliament is adversarial. And the reason is not entirely dishonorable. People enter politics and aspire to ministerial office because they want to get things done. They want to make a difference. The requirement to get parliamentary authority is an obstacle which has to be overcome, a hurdle. Over the last 300 years or so, the executive has devised various ways of getting its way in Parliament. Political parties were formed to establish majorities. Devices were developed to keep members of parties in line. The whipping system, patronage, selection and deselection of party candidates, and much else. Even so, governments have to get powers from Parliament, and this imposes a restraint on them. They have to make their case to Parliament, and even when the governing body has a majority like the present one, they have to watch their step. In recent years, the executive has devised new ways to prevent Parliament from putting an effective brake on the government's freedom of action. Governments today increasingly introduce legislation in skeleton form, defining powers in the broadest terms with details set out in statutory instruments. These statutory instruments, Parliament is debarred from amending, unlike legislation, and by convention does not defeat. Of the thousands and thousands of statutory instruments each year, the House of Commons has not rejected one since 1979. And the House of Lords has rejected only 6 since 1950, nearly 3/4 of a century. The consequence of this is that the executive obtains powers which Parliament does not effectively scrutinize or control. There is currently a particular egregious example of this, more than one actually, but in the Northern Ireland Protocol Bill. This bill is objectionable in itself, since it seeks powers for the government to break an agreement which this country entered into knowingly only a couple of years ago. But the further powers which the government has included in the bill are also outrageous. Because it does not know how the negotiations with the European Union will turn out, the government is seeking powers to amend by statutory instrument clauses in the bill once it has become an act, even including repealing the act itself, with no parliamentary involvement. This means that it is seeking to change the law or even repeal it without any effective consideration by Parliament. Fortunately, the government has suspended proceedings on this bill in the House of Lords until it sees how the negotiations with the EU will develop. A similar example currently before the House of Lords is the government's retained European Union law revocation and reform bill. In this bill, the government is seeking powers to abolish or amend laws inherited from our membership of the European Union without any effective parliamentary control. This sort of thing previously happened when King Henry VIII sought to make law by proclamation, and the Parliament at the time stepped in to prevent him from doing so, at much greater risks to themselves than the legislators face today. The situation is sufficiently serious that in November 2021, 2 House of Lords select committees issued reports entitled, and I quote, "Government by Diktat, a call to return power to Parliament," unquote. And the other report was entitled, quotes, "Democracy Denied, the urgent need to rebalance power between Parliament and the executive." So in terms of the balance between government, Parliament, and the judiciary, which I quoted to you from the head of the government legal service, on which the rule of law depends, it seems to me that Parliament is now underweight in this country. We like to call Westminster the mother of parliaments, but in the face of a government with a large majority in the House of Commons, I'm afraid that she looks more like a toothless and impotent old lady. This is what Lord Hailsham had in mind as long ago as 1976, when he referred in his famous Dimbleby lecture to our government being a, quotes, elective dictatorship. I submit that this is serious. We only have to look around the world to consider the lessons of European history, to remind ourselves of what can happen when autocratic regimes can dominate Parliament so that they can enact at will whatever laws they want. Now, I'm not saying we're at that point now. We have deep-rooted traditions of personal freedom in this country and 5-year elections. But even so, we cannot be too relaxed about the executive finding ways to ride roughshod over Parliament. But you may say, hey, wait a minute. Why doesn't Parliament use the powers which it has? Statutory instruments have to be laid before Parliament and can be voted on. Why doesn't Parliament exercise control by voting down the statutory instruments it doesn't like? And that's a good question. The answer is that the House of Lords does not vote down statutory instruments except in the most extreme circumstances, because as the non-elected House, it does not feel that it can reject the measures of the executive single-handedly. But I'm afraid the reason why the House of Commons does not do so is more discreditable. The opposition parties reckon that sooner or later they will be the government, and then they will not want their own statutory instruments voted down. This is not a story, I'm afraid, which reflects well on our Parliament. And in my view, it follows that if we cannot rely on Parliament to restrain the executive and their excesses, we have to look at the courts to do so. So I now return to the other two legs of the tripod of the Constitution, namely the balance between the executive and the judiciary. And to the two questions which I put to you, the audience, at the beginning of this lecture. Was the Supreme Court right to intervene and annul the use of the prerogative to prorogue Parliament in 2019? My own answer, with the majority who are here, is emphatically yes. In the absence of any colorable justification, the executive's suspension of Parliament at a crucial moment in the Brexit negotiations was a flagrant abuse of prerogative power. Similarly, the government's intervention in 2017 to give notice of our withdrawal from the EU, thus effectively reversing without any parliamentary process the legislation which took us into the EEC in 1972, would similarly have been an abuse of power. However, as you might expect, the government did not like these two interventions by the Supreme Court. Its response was signaled by its failure to stand up for the independence of the judiciaries against attacks in the pro-Brexit media. And we all remember the headline, labeling judges as the enemies of the people. Subsequent to the 2019 election, the government carried forward its campaign to clip the wings of the courts by establishing a study of judicial review under an independent panel chaired by a Conservative peer, Lord Fawkes. That was one measure they took. A second one, when repealing the Fixed Term Parliament Act and restoring to the Prime Minister the right to call for a general election at will, the government included what's called an ouster clause. This clause, included in the legislation, says explicitly that an appeal cannot be made to the courts to intervene in a dissolution of Parliament, as had happened with the 2019 prorogation. Several members of the House of Lords, including myself, sought to remove this ouster clause from the bill, but we were unsuccessful. However, we can console ourselves with the thought that it is very unlikely that there would ever be an appeal to the courts to intervene in a government's decision to seek a general election, since opposition parties usually relish the opportunity of the electoral battle and the possibility of winning power themselves. Nevertheless, there are signs that the government will try to use the device of including ouster clauses in future legislation in order to remove the risk of the courts reviewing the exercise of the powers conferred by the legislation. For my part, whenever I spot such clauses, I will oppose and seek to remove them, as will others in the House of Lords. The outcome of Lord Fawkes' review was a disappointment to the government. It recommended only two fairly technical changes to judicial review, which have now been incorporated in the Judicial Review and Courts Act 2022. Otherwise, judicial review will continue as before. I end by quoting the final observation of the Falk's review panel. It was, and I quote, "Our view is that the government and parliament can be confident that the courts will respect institutional boundaries in exercising their inherent powers to review the legality of government action. Politicians should, in turn, afford the judiciary the respect which is undoubtedly due when it exercises those powers." I say, hear, hear to that.
Thank you very much. That fascinating talk. Can we now have questions first from the audience here? Yes, would you can you hand the microphone and could you give your name so those online know who's speaking? Thank you.
I'm Gabriel. I'm a student with Inner Temple. You are lucky, Lord Butler, to sit in a hung house in Parliament where you have an option to defeat the government. It seems to me some of the issues you've identified result from our majoritarian electoral system. Are you of the belief that government would be more respectful of Parliament's constitutional supremacy if we reformed our electoral system?
Well, our electoral system does a deal. I'll stand here. What it does produce for 5 years what Lord Hailsham called an elective dictatorship. It produces effective government. However, it does depend, the exercise of that position and large majorities in Parliament does depend on what Peter Hennessy called the good chaps principle, which is that the executive will not use that position to abuse what has been traditionally regarded as the restraints. It won't cross the lines. I think recently we have had some evidence, in my view, of those lines being crossed. However, I would not go so far as to want to change the voting system to a system which inevitably produced hung parliaments. I think I'd rather that mind you, I'm steeped in history in this, but I would rather we retain the present system of first past the post, but did everything we could both to encourage the governments in power to act within the constraints, and if necessary, though I regret it, having watchdogs that try to ensure they do.
Now I have a question on an aside in the lecture. This is, Lord, but you say the fact that 80% of judicial reviews are immigration related demonstrates an exploitation of our liberal regime. Might it not reflect in truth the disproportionately poor and often unlawful decision making by the Home Office?
Well, I mean, I've never been a member of the Home Office, so I'd always feel free to criticize them. And indeed, there are some grounds on which the Home Office deserves to be criticized. But I think one would say that that sort of imbalance is a bit suggestive that the ability to seek judicial review is being used. So I can't believe that such a preponderance of decisions by the Home Office in immigration cases are misguided. Actually, of course, it also is the case that not many of those judicial reviews are successful. Only a very small minority.
Yes.
Hi. When I was in college or secondary school, they taught us that the judiciary, the legislative arm of government, and the executive are independent, yet a member of the state. They're independent bodies. They're independent bodies. The legislative arm, the executive arm, the judiciary, so is that what we have now? Can we still say we have independent three arms of government? Are they still independent with this Brexit interference, judiciaries and legislatives interfering in each other's affairs? Can we still say, like we were taught in secondary school, that they are independent bodies?
Well, the judiciary is certainly independent and must be. The Parliament cannot be independent of the government, because the government has a majority of its members are supporters of the government, and the government appoints to the executive members of their party in Parliament. So the relationship between the executive and Parliament is very much interwoven. That is perhaps another reason why it's so important that judges should be independent and be able to reach an independent judgment of the actions of the executive.
I have no other questions at the moment online, so yes. Yes.
Thank you. I'm Sam Cook, one of the Parliamentary Council. Lord Butler, isn't it always difficult to measure the control exerted by the Commons over the government by the number of defeats, because simply the government will never put anything to a vote till it gets a whiff of defeat?
Sorry, yes, I know, I didn't quite catch it.
Isn't it always difficult to measure the control exercised by the Commons over the government by the number of defeats inflicted by the Commons, as you sought to do in the case of statutory instruments, for the simple reason that the government will never put something to a vote in the Commons if it has a whiff of defeat?
Well, yeah, I mean, I think that is true, although, but I mean, with statutory instruments, I don't think the choice is really even given to the House of Commons, as is evident from the fact that no statutory instrument ever gets defeated in the House of Commons. And you're not telling me that all of them command, or would command, if there was an ability to vote against them, that sort of universal approval. Now, it is true, of course, that in some cases, the government can't be sure of its majority. And that happens with legislation, and there's been a lot of examples of it. When a government has the sort of size of majority that it has at the moment, although that majority is reducing, then it is unlikely that the government will be defeated. There was a prospect that it would be defeated in the debate on fracking. And you're right that for that reason, the government will hesitate before putting something before Parliament when it's not sure of its majority. And if ever there was a time when the governing party was split, it's now. But even so, the members of the party in the House of Commons, I think, will hesitate to vote against the government. There may be things coming up on which the government will have to take a chance about that, where it may be difficult to get legislation through.
Yes.
Thank you. My name is Alistair Holder-Ross. I'm a student member here. Thank you very much for a very interesting lecture. The question I had is about the balance of power and the role of the House of Lords in that, and whether or not you think one way of giving Parliament more teeth as part of the balance of power might be a reformed House of Lords, and actually the removal of the House of Lords and the replacement of it with an elected chamber. Thank you.
Well, I would never be in favour of giving the House of Lords more teeth while it remains an appointed chamber. Primacy has always got to belong to the House of Commons. What the House of Lords can do is, by virtue of the fact that it's appointed, and if good appointments are made, it contains a range of experience and expertise, is to scrutinize legislation in a way that, frankly, these days, the House of Commons doesn't often do. And to then pass amendments, but that's only giving them to consideration to the House of Commons. If our system worked really well, I mean, this is a different point, but if our system worked really well, I think that would be very satisfactory. But it doesn't work well because the House of Commons, the executive in the House of Commons, tends to have a sort of reflex action that if something has come from the House of Lords, unless it's got really quite widespread public support, they reverse it almost without thought. So it could work better that way. Now, but the question is, does the House of Lords need reform? Emphatically, yes, it does need reform. I think that the way in which, over all the years, but perhaps very markedly in recent times, it's been used as a form of patronage, is very bad and very unhealthy. People also talk about the size of the House of Lords. And it is very bad public relations that the House of Lords is larger than the House of Commons and larger than any second chamber except for in the Republic of China. But I'm rather a bit more relaxed about that. I think David Hunt would probably agree with me. The number of people who actually do the business in the House of Lords is a minority of the membership. We've had some interesting votes last week. And out of the 800 plus members of the House of Lords, the people who actually voted were only just over 400. And those are the people who turn up regularly and they do the business. In general, I think it would be fair to say that people who are appointed to the House of Lords simply as a result of patronage get bored pretty quickly and don't turn up. You know, you've got to be a bit devoted to the political process to want to take part in it. But having said that, yes, the House of Lords does need reform, both for substantial and for public relations reasons.
Yes, the back there.
Patrick O'Connor, barrister. Lord Butler, thank you very, very much for your comments. I'm asking a question really about the royal prerogative. So about 25 years ago, a parliamentary Home Affairs Committee was investigating the use of the royal prerogative. And they, not surprisingly, sent a letter to the Treasury solicitors asking for them to list the extent of the prerogative powers. And after a very embarrassing delay of several months, the Treasury solicitors wrote back saying, unfortunately, it has not been possible to provide you with a list of all the examples of prerogative powers. Now, as you know, orders in council under the prerogative have been used repeatedly in the Chagos Islanders song, the Chagos Islands scandal, whereby they were excluded, thrown out and excluded from the island. And the relevant order in council, one of them was instigated by Jack Straw, who was then, I think, the Foreign Secretary. Now, publicly, on a Radio 4 programme I was involved with, Jack Straw apologised for using that procedure and admitted that he had done so deliberately in order to avoid parliamentary scrutiny because it was so scandalous. And it was 100 years ago, I think, in De Keyser's Royal Hotel, that our law lords criticised the prerogative powers as being completely out of date. Now, do you have concerns about the continuing influence and availability of our prerogative powers, particularly in light of the Civil Contingencies Act, which provides for just about every single emergency power the government could possibly need in any circumstance?
Well, I'm not quite sure I heard the whole of it, but I mean, in general, of course, it is the fact, and you will know, that over the years, the area of prerogative powers has been progressively reduced so that more and more has to be decided by Parliament. And that is right, in my view. I mean, I think that the Parliament should be the boss, and that prerogative powers should be limited. And so, as I say, I'm in favor of that. And whenever one comes across a bit of prerogative power on the whole, I would support legislation that turns it into something that has to be done by Parliament. However, I'd be happier about it if I thought that the House of Commons gave more attention to the exercise of its powers than it currently does.
My name is Michael Stephen. I'm a barrister member of this inn who used to sit on European legislation standing committees in the House of Commons, where day after day we were presented with European legislation and we could not amend one single word of it. And yet the public were led to believe that this legislation was being subjected to parliamentary scrutiny. We are no longer in the European Union, but could that ever have been defended? Could that procedure have ever been defended as being democratic?
I mean, I think the theory was, but it was only a theory, that our Parliament didn't need to debate it because it had been through an effective process in the European Parliament. Now, that was, of course, a fiction. And but anyway, it was the necessary fiction because we were a member of the EU and we had to accept that. Now, whether you're a Brexiteer or not a Brexiteer, I welcome our Parliament having more powers, but considering legislation properly. Now, I think that the legislation that we have inherited from the EU was not passed in a democratic way, but that doesn't mean that we should now dispose of it in a non-democratic way. What we should be doing is looking at it seriously, having the opportunity to consider what we want to keep and what we want to change, and put that through a proper process of Parliament. Now, I acknowledge because of the scale of it, that is a difficult thing to do. So I wouldn't mind actually, personally, if it was done by statutory instrument, but in that case, I'd want this to be a more effective process for scrutinizing statutory instruments.
I just have a question here online, which again, concerning this unspecific list of prerogative powers. The person asks, who decides which powers should be non-justiciable? Shouldn't this be left up to Parliament? Or should it be left to the courts?
Well, I think that, yes, there shouldn't be boundaries around the courts. And indeed, I mean, I think, you know, it's been, unless there's an ouster clause, I don't think there are any boundaries, unless, you know, this is clearly a legitimate political matter, something that has been a political decision. But subject to that, I don't think I would attempt to draw boundaries.
Now we're coming towards 7 o'clock. I think I saw one other hand. Did I somewhere? Yes, there. Thank you.
Good evening, and thank you very much for your lecture. My name's Remy Trovo, also a student here at Inner Temple. My question would be, what do you think would happen if Parliament, who is theoretically sovereign under our constitution, were to attempt to introduce legislation which would seek to overturn the supervisory role of the courts completely?
Well, I hope that that is a situation. I mean, you remember at some point in my lecture, I said, you know, we've got to be serious about this, that if you look at the history of Europe and other European countries, then a government which had such a stranglehold on Parliament and sought to do that could do it, and it would be disastrous. And so one likes to think that we're not at a point when any government, however malign, could get away with passing or even introducing legislation of that sort. Things haven't reached that point. They're pretty bad, but they haven't reached that point.
I wonder if yes, that's one.
Hi, I'm a student as well in the Temple, and I'm also a civil servant as well. So I get best of both worlds, I guess.
How do you manage to combine the two?
Struggle, massive struggle.
Good for you.
But yes, I guess my question is the new Bill of Rights a good example of the executive effectively curtailing the power of the judiciary, especially when it comes to making declarations of incompatibility under Section 3, although I do understand that Section 3 is not necessarily being modified?
I can't do, I think I'm going to waive that. I think, yeah,
rather more specific.
that is too difficult for me.
Okay, I apologize. Okay.
Could I exercise an abuse of power and ask a question from the chair, which is this: you made a particular point about the powers that are being used by way of statutory instrument, or the power that's been given to effectively repeal. Would you say that the courts ought to find ways of striking such provisions down by some mechanism or another?
I don't think they could, because I think, I'm not an expert on this, and there may be people in the audience who are. The process of statutory instruments is enshrined in the law. I mean, there is a Statutory Instruments Act, and that is what prevents statutory instruments being amended. Now, could interesting question. Suppose that the inherited European law bill goes through, and somebody sought a judicial review of a statutory instrument, saying this could not have possibly been considered because it fell under the sunset clause. Could the courts consider that Parliament had passed it without due process? I think I leave that to.
Put it this way: would you be happy for it to enlarge its power, the judiciary to enlarge their powers by creative activity?
Yeah.
Yeah.
Well, I would. I mean, as you will have gathered, I am all for the judiciary preventing the abuse of executive power. And where we see signs of that, I would never argue against the judiciary stepping in.
Thank you very much. Well, on that note, I think we'll bring the evening to an end. Thank you very much. Thank you. Thank you. A lot of questions. Yeah, good.
Lord Butler, just before we depart, wanted to, on behalf of the, thank you very much indeed for an illuminating talk, which clearly came to the most satisfactory conclusion any lawyer could, or judge, more importantly, could ask for. But I think we can all agree we've heard today from a true public servant who absolutely understands the position of what should happen in a democracy. And so long as people like your good self are sitting in the House of Lords, at least we have a bit of a safeguard to hang on to. So thank you very much indeed.